Welcome back, guys. I am Brad Woodall with probateresource.com. I'm continuing our video series today in regards to Tennessee specific topics, and I'm here with my friend April Jackson. She's a probate and estate attorney in Nashville, Tennessee. We're talking all things Tennessee today. And this specific question is in relation to holographic wills. First of all, what is a holographic will?
Holographic will is also known as a handwritten will.
It's not like futuristic, electronic projection, but no.
No, I love the idea of like a recorded will, but
Sure.
Guys does. So,
Right.
a holographic will is just a will that you have made in your own handwriting or somebody you love has. That it should be dated and it has to have a signature on it, saying that it belongs to the person who wrote it. And that is really the only requirement to write your own will. Like, you can write your own will, it just needs to be in your own handwriting, signed and dated. Now, the quirk comes when we actually go to admit that will to probate. So in Tennessee, if you have handwritten your will, there are a couple of things that you could do in order to make it easier to probate.
Okay.
The first thing is to treat it like the normal, like if it wasn't handwritten. So basically attach a page that has, specific language attesting that you did have witnesses there who should have been there when you signed it, that everyone was in the same place at the same time, that the witnesses saw you say, "Hey, this is my will. Will you be my witness?"
Mm-hmm.
So those witnesses should not be related to you. They shouldn't be inheriting from you. They need to be over 18 and they need to have the legal capacity to be a witness. Which is probably the case. So that if you do that, then you have the witnesses to your will, which makes it, kind of under a traditional will. Now, in order to admit that will to probate, you are going to either need affidavits from those witnesses, if you had witnesses, or so like those, normally how we would do it, if it's just a typed will, is you're going to have the witnesses sign the will with the will maker, and then there's going to be a separate document that's the affidavit that's notarized, so that can be admitted into court. Now, if you did not have witnesses for your handwritten will, then you are going to need to, or your attorney or your family is going to need to find two people who can come to court and say, "Yep, that is Johnny's handwriting."
Okay.
Which, nowadays we do so much more by email. I have a lot of friends that if you ask me to identify their handwriting, I'd be like, "I think so."
Yeah.
We use, it's texts and emails, and not a lot of handwriting happens anymore.
Sure.
So you need people who can actually come to court and say, "I am familiar with this person's handwriting. That is absolutely their handwriting. That is, at the time that I understand they wrote that, they didn't have any capacity issues." And so that's kind of, you can absolutely handwrite your will. The problem is getting it through probate.
Yes. Right. Yeah. More often than not, we've dealt with people who call us, they want to sell a property, and they say, Dad had a will. And then from experience, it's okay, I need to see Dad's will before I go down this path. And then I see Dad's will, and I'm just like, oh my gosh. I hate to break it to you, but this probably isn't going to fly. And let me get you in touch with my attorney, and he'll tell you why. But yeah, we've dealt with that a lot. And we've had cases, I mentioned to you offline, we had one where we had to get a hold of the the witnesses. And luckily, they were both still alive and both still at that phone number that they had listed on the, because on the will it had their phone number and all that. And they were able to verify and sign an affidavit. Yeah, in fact, we were there because there was a slight discrepancy in the will, and we needed them to attest to that. So that happens. And you mentioned the witnesses. My witnesses on my will were one of the employees at the UPS store and the other lady that was standing there at the counter that I got her. Yeah, I got their information and all that because I went to the UPS store to have mine notarized and everything. Yep. So, yep.
And that's perfect. 2 witnesses and a notary. That is the standard for completing all those processes, so you don't have to go through with any witnesses you need to open probate.
So to recap on this, the components or the guidelines we need are, it needs to be dated and signed, right?
Yep.
And
entirely in your own handwriting.
Entirely in your own handwriting. Okay. And you need witnesses. Well, you don't need witnesses, but you strongly encourage witnesses.
Right. Yeah. So that's the thing. It's like, I can handwrite a will, but I want to be thinking ahead of who is going to actually come to court and say, I recognize 𝐀𝐻𝐿's handwriting. And so that puts a burden on, your family, your friends, whoever that is. Makes work a little bit more difficult for the attorneys if we're having to put time into that. So it makes it more expensive. When really what you want is the witnesses to sign that they saw you sell it, that they saw you sign the will, that everybody was in the same place at the same time.
Mm-hmm.
And they're going to sign a separate affidavit saying they saw you sign the will. And that's where the notary comes in. So yeah,
got it.
If you have those things, it's not impossible, but
the court has to approve it. Right. Yeah. And if the court doesn't approve, especially in the case if your will is, let's say it's conveying things that aren't in congruence with the laws of intestate succession, then and the court deems it not valid, then you kind of have to follow what the laws of intestate succession say.
It is the same as if you never wrote a will.
Right. So
except it might be more expensive because your family's trying to get the will in.
Yes. That's happened before. So awesome. Well, hey, April, thank you so much for kind of clarifying that. That's like a very common question that's actually asked in terms of handwritten wills, or most people don't ask holographic will, but handwritten will, is it valid? So I really appreciate your time, April. Guys, if you are interested in checking any of our other videos out that we did with April in regards to Tennessee, you can find those on probateresource.com/Tennessee, or on our YouTube channel. We have a playlist specifically for Tennessee. April, if people want to get a hold of you and your firm, we've got a link below in the description. And also on our Tennessee specific page, we have a link, and you've got some cool tools over on your website that can help people with some of the questions they might have, correct?
Yeah. We try to have, resources that people may need, that they don't need an attorney for. And then we also have a monthly newsletter that shares additional resources. So.
Cool. An attorney giving out free stuff. That's awesome. Love it. Awesome. Well, April, thanks so much for your time, guys. Check out our other videos if you have any other Tennessee-specific questions. Or if you have a question that we didn't answer, you can reach out to April. She will be the expert in the state of Tennessee and the person you need to talk to in Tennessee regarding probate or estate matters. Thanks again. Talk to you guys later.